Chapter 3 is going to cover the adjudication process. So, a criminal case usually starts in one of three ways. The police investigate and arrest. A private party issues the citizen's arrest, or by indictment by a grand jury. So the police can start the process several ways. One is an arrest based on an arrest warrant, and the other is they can start the process without a warrant. So if they are doing it with an arrest warrant, the application for the warrant will be the first official document filed with the court. Keep in mind the standard to make an arrest is that you have to be able to show probable cause. Without a warrant, the complaint is the first document filed with the court, and that's the initial document that states the criminal charges. So the prosecutor is the person who decides which cases will be filed and what crimes will be charged. In order to do this, though, they need a report from the police that clearly states the facts of the case and what information is available. So while they don't have any precise standards for filing charges, they're usually looking at whether or not a case is winnable. So things they look at here: how strong is the case? Did the police conduct their investigation thoroughly? What crimes were committed? Were the suspect's constitutional rights violated? And are the witnesses in the case credible? The complaint has to state the facts for each charge, and the description must cover every element in the definition of that crime, generally using wording from the penal code. So they need to show also that the crime occurred within the court's jurisdiction and show the date, because we want to be concerned about making sure that charges are filed within the statute of limitations. If the police seek an arrest warrant prior to arrest, they have to follow formal procedures. So they're going to make out an affidavit under oath of all facts involved in the case. They're typically going to use the same wording as a complaint, and many states will allow the arrest warrant to take the place of the complaint. If a private person wants to file charges, they're usually required to go to the prosecutor's office and give all the information under oath. Once the complaint is filed, the suspect is legally known as the defendant. So the defendant's first court appearance is usually their arraignment. This might also be referred to as a first appearance or a preliminary hearing. And it has several possible purposes. One is to inform the defendant of the charges against them. It is also to appoint a defense attorney, set bail, and enter a plea so that they can set the next appearance. Now, your plea options are guilty, not guilty, and nolo contendere. Nolo contendere means no contest. It's similar to a guilty plea and is treated as a guilty plea, but it means that the defendant is not admitting to guilt. So the guilty plea, in quote, cannot be used against them in future criminal proceedings. The next step is a probable cause hearing, which is sometimes combined with the arraignment, and this is mandatory within 48 hours of arrest. And this establishes that there is enough possible evidence to go to trial on the charges. It's basically the hearing in which you establish probable cause, that the crime was committed and that it was committed by the defendant. A preliminary hearing is required in most states if an arrest was not based on a grand jury indictment. It's kind of like a brief little trial for the judge to decide if there's enough evidence to determine if a crime occurred and determine if the defendant in custody should stand trial. So remember, in the prior chapter, we learned the term prima facie case, and that's basically what we're looking for here. In some states, this is done in conjunction with the arraignment, and it's usually the first time witnesses are required to take the oath. The rules for evidence here are very relaxed, and if there is sufficient evidence, the defendant is bound over for trial. The prosecution then files an information, which is the details of the charges. Now, sometimes cases come to court via a grand jury. And a grand jury hears evidence to determine if a crime occurred and who committed it. And this is required in some cases as part of the Fifth Amendment. It's made up of citizens, and it's theoretically independent from the prosecution or police. They can call witnesses and hear evidence in secret, and no defense counsel is present. So you're not even entitled to know that grand jury proceedings have begun in your name. Evidence that can't be used at trial can be used in a grand jury. If they decide a crime was committed, then what they'll do is they'll hand down an indictment. So prior to trial, a judge might hold a suppression hearing. This would be based on a motion by either side to exclude evidence from being used at trial. And here they're going to use the normal rules of evidence. Most evidence is suppressed. When suppressed, is done so because of a violation of the Constitution, either an involuntary confession or an illegal search. Then we're going to begin the process of what's known as discovery. It's a process whereby each side discloses what evidence and witnesses it has or will use at trial. The prosecution has to disclose both exculpatory and inculpatory evidence to the defense, and that's part of a Supreme Court case, Brady v. Maryland. So they often refer to that as Brady material. So exculpatory evidence is evidence that would exclude you from being the offender, and inculpatory is evidence of guilt. So the defense could refuse to disclose the defendant's testimony because that, you have a Fifth Amendment right not to incriminate yourself. The process can be very informal, or it can be formal if ordered by the court. So let's look at the Brady case. Mr. Brady was accused of murder and placed on trial. He admitted being involved, but claimed that Mr. Bobbitt had committed the murder. Mr. Bobbitt confessed to the police that he had in fact committed the murder, and the police had his signed confession. Brady was convicted, but his conviction was overturned, and this became the rule that the prosecution must turn over all exculpatory evidence to the defense. So in this case, the police knew that there was evidence, or the prosecution knew there was evidence that pointed towards Brady's innocence, but they didn't disclose it to the defense. So the courts are required, prosecutors are required to do this. So the state often controls almost all of the ability to gather, preserve, test, present, and share evidence. But how do we know that the state doesn't abuse this power? Most prosecutors are elected. Do they run promising full disclosure or greater penalties for offenders? And how do we deal with conflicts of interest like this? So let's talk about plea bargaining. We have both charge bargaining and plea bargaining. Charge bargaining is where you negotiate a deal based on the charges that you'll face, the number of charges or the severity of charges before they're actually filed. A plea bargain is where we're negotiating guilty pleas and the level or charges or sentence. The idea here is that it's going to produce certain results for each side. Now, another case results in what we call a Boykin waiver. This is where the defendant acknowledges he was informed of all his rights and details of the plea bargain before accepting it. Now, in most cases, somewhere, upwards of 90% end in a plea bargain. As I mentioned, almost all cases of felonies do not go to trial. So what happens in the pre-trial stages? Well, one thing that's going to happen is jury selection, also known as voir dire. So you're going to take a veneer, which is a pool of potential jurors, and if you've ever been called for jury duty, then you have been in a veneer, and they're going to question jurors to select a jury. The jury is often screened with a preliminary written questionnaire, which asks some basic facts about the jurors and looks for any obvious reasons to disqualify someone. As jurors are questioned, you can challenge them for cause, or you can challenge them with a preemptory challenge. A challenge for cause is where you're dismissing them because there's prejudice or relationship to the trial, witnesses, or participants. A preemptory challenge is when you want to dismiss a possible juror for tactical reasons. You don't think they're going to be good for your case. You have a limited number of these, whereas you have unlimited challenges for cause. So some things to think about. One side may seek to sequester the jury away from news about the trial. We have several courtroom participants. We have the judge, who is the trier of law, the prosecution and defense attorneys, a court reporter who's making a record of the trial. And technology is used to make an accurate record of the trial. Increasingly, we're relying on machines as opposed to clerk transcripts. So a lot of places there is audio recording of the trial. At the beginning of the trial, each side will give an opening statement, and it's voluntary for the defense. The defense doesn't have to give an opening statement, but usually does, and they're going to explain what they seek to prove. The prosecution then goes first and presents its case in chief. They're going to have witnesses sworn in to prove each element of the offense. They're going to engage in direct examination of their witnesses. These should not be leading questions, and they should not be long narrations. Now, the defense during the case in chief can object at the proper time before or during trial. Okay, and remember we talked about the contemporaneous objection rule, that you want to object after the question is asked and before the answer is given. They're going to seek to exclude or limit opposing counsel evidence, and then the judge will rule on that. When someone objects, the judge could sustain the objection, which bars its admission, or overrule it, which would allow the evidence in or the question to continue. So we're also going to question witnesses at trial. Evidence is only admitted via a witness in most cases. So generally we need a witness to lay the foundation for all evidence. So even if we're going to admit, say, a weapon into a trial, we need the person who found it to lay the foundation, lay a foundation and testify as to when and where and how they found it. During cross-examination, this is a critical constitutional right. We use this to point out flaws and inconsistencies. This could be limited if a witness needs special protection, say they're a child or they have a mental handicap. Other things that can happen is you want to try to impeach the other side's witnesses. Okay, so that's where you attack the witnesses based on some problem with their testimony or with the witness themselves. Then what's going to happen is if the witness has been impeached, the side that originally called the witness is going to try to rehabilitate them. Okay, they're going to try to explain that problem or issue and make the witness credible again. Once the prosecution rests their case, it's the defense's turn to put on their case in chief. The defendant doesn't need to offer any evidence. There is a presumption of innocence, but they're generally going to call witnesses and present evidence. They may seek to show their good character and introduce character evidence. But when you do this, you're actually opening the door to the other side introducing character evidence as well. So you want to be careful about whether or not you do that. We also have a rebuttal and a rejoinder. Rebuttal is when the prosecution calls a witness after the defense's case. So the defense has put on some witness, testified to some fact, and the prosecution is going to call somebody to rebut that. Okay, they're going to reject that testimony, and it's about an issue that the prosecution has not previously raised. A rejoinder is when the defense calls a witness after rebuttal to reject that witness, the rebuttal witness. The ending stages, each party has a closing argument where they're going to sum up their case and offer their explanation. The judge will explain the law to the jury and give them instructions, and the jury will deliberate in private. They're going to review the evidence and reach a verdict. It does not need to be unanimous in all states. It can be by majority in some states. After a trial, several things could happen. So you could have a hung jury where there's no verdict. This could then result in the prosecution retrying the case. Once the jury announces their verdict, they might be polled to confirm that each person in the jury did vote as indicated. If the defendant is found guilty, there'll be a sentencing hearing. There's generally a delay in order to allow the judge to consider the verdict. They might get a report on the defendant. In a capital case, then what happens is there's another trial because the jury is the one who determines whether or not someone will receive the death penalty. And then, as we talked about before, we have a post-conviction phase where appeals are filed. And that wraps up the adjudication process.